SJC-13528, Commonwealth versus Marquise Mitchell. SJC-13529, Commonwealth versus Pedro Ortiz. SJC-13530, Commonwealth versus Terrance Pabon.
Okay, Attorney Neves.
Good morning. Catherine Neves, representing defendant appellant Marquise Mitchell. With me at counsel table are Richard Klebanner, counsel for Pedro Ortiz, and Richard Goldman, counsel for Terrance Pabon. I will be presenting argument on behalf of all three defendants appellants this morning. If you ask me a question, and I fully understand the question, and I have a clear memory on the subject matter of the question, and I know my answer is yes, but I say no.
We've gotten conditional answers from lawyers before, though.
I'm sorry?
We've gotten conditional answers from lawyers before.
Right. The answer's not an honest answer, right? I know the answer is false. I know the answer is yes, but I say no. I know the answer is false. Or in the parlance of the trial judge in this case, my answer is knowingly inaccurate. And in the context of this case, and in my hypothetical, honest and knowingly inaccurate are synonymous.
Can I ask you about the standard of review? Because we're looking at abuse of discretion, correct, and clearly erroneous on the judge's factual findings regarding the juror?
Yes, and I have no quarrel with the judge's factual findings. She found that the juror's answer was knowingly inaccurate. That means the juror wasn't mistaken like the juror in Amaralt. She did not have a failure of memory like the juror in Amaralt. She knew, and to quote the judge, the answer was inaccurate, and the juror knew it was inaccurate, in that the juror knew Carl had been convicted of crimes and was incarcerated. That's at defendant's brief at 59.
What about the conditional part that the judge glossed onto it?
At the end, I think that's not a factual finding. That's a faulty application of this court's constitutional principle in Amaralt, whether the juror was aware the answer was false, which is the first prong of the two-prong standard, which is derived from McDonough as well. The inaccuracy was not dishonest, however, in that it did not arise from any motive to mislead or conceal, but was based on the juror's independent evaluation of relevance. So the factual finding is the juror's answer was inaccurate, and she knew it was inaccurate. That's her factual finding. In this court's words, she was aware her answer was false. That's the question of whether the answer was honest in Amaralt. And I think that's the only way that you can get to an answer like this. Is the juror aware when she gives the answer that it's false? So the independent evaluation of relevance goes to bias, right? And it's not bias. Bias doesn't necessarily have to be toward these defendants, although there are troubling connections that were developed post-conviction. But bias is a potential juror who will favor her own sense of what she thinks she should do or disclose or not disclose, and what the court tells her she needs to do. This is a juror who answered no to the question whether she had a family member who was charged with a crime, convicted of a crime, despite the fact that she knew her half-brother was incarcerated at the time for gun charges out of Boston. She failed to correct her answer on voir dire after the trial judge very carefully said, look, a lot of times people don't fill this out completely. We really need you, and so maybe your questionnaire isn't complete. But we really need to know, even if you think it's irrelevant, please tell us at sidebar. We need to know. She came to sidebar, she said nothing.
What do we do with the fact that the judge relied on the fact that this juror had also denied her own involvement with criminal convictions?
Well, I think what the trial judge said is that, yes, she also exercised her own independent evaluation of relevance as to driving without insurance. She didn't disclose that as well.
So she was consistent in her independence.
Consistent in choosing what she was going to tell the court based on what she decided she'd tell the court.
Right, in that particular instance, the judge decided that she wouldn't be excused for cause after explanation, isn't that right?
No, the parties said no problem, because,
So the parties also agreed.
said with respect to that, okay. She said, it was just a driving without insurance. I didn't think it was a big deal. The parties in that context said, we'll let it go.
That's relatively common.
That's not, it's not, my brother is the leader of the Lucerne Street Dogs, and he's incarcerated for gun charges, and it's, that's significant. And in fact, the trial judge in this case highlighted that question.
And the parties had a chance to evaluate whether or not they wanted to let her go based on.
Well,
the
just
answer.
based on that.
Right. No, that's what I'm saying.
Just based on
comparing those
that,
two.
yeah. And I think certainly, I'm sure the thinking was it was a minor issue. She's from the community, you don't know anymore. You say, I'll take that juror.
Can you help me? How do we evaluate whether or not this would have been a challenge for cause? It seems very speculative.
I don't think it is. And I think what the trial judge, and I think this is also something that the trial judge erred in applying the constitutional principle on the second prong, which is once you determine that a juror has failed to answer honestly a material question, you look at whether there would have been a challenge for cause. And, you look at, the judge, an objective judge, looks at the dishonesty and the reason for the dishonesty to decide whether the juror was capable of, being an impartial juror. In this situation, however,
The trial judge disqualified another juror, right, for the same mistake, right?
absolutely.
And describe the other juror for me, just remind me.
He had juvenile adjudications that were sealed, and he did not disclose those on his juror questionnaire.
And she
they were-
disqualified him for cause? What-
It was discovered when the Commonwealth ran his quarry and found them. And they brought him in, and he said, I thought they were sealed, I didn't read the form carefully, I didn't realize, he sort of did the same kind of thing. They were sealed, I didn't think I needed to tell the court, right? The same sort of evaluation.
What's the scale we use when someone, say we get past the first emerald step where someone is dishonest, and then we go on to whether or not this would be appropriate basis for cause. So with the juror that Justice Kafka mentioned, the person misrepresented his own criminal history, and the judge said, no, we can't have that on the jury. Here we have this case, but what would be an example of a case where a juror is dishonest, but there does not lie a challenge for cause? Can you think of one?
I can't think of one right now off the top of my head. I'm sure there is such a thing. It's not just the,
Would it be similar to the first incident that happened with the juror, where the juror says, I got a cough, I thought that case was dismissed?
Right, I didn't realize. Yeah, I think, it's not honest because you have that, right? And you should have disclosed it because honest means free from deceit or any untruthfulness. But in the context of, can this juror be impartial, right? And getting back to Your Honor's question, I think that you have to look necessarily, when you're in this context, post-conviction, when you're looking at a motion for a new trial, that's the only time this came to light was because her brother taunted Mr. Ortiz, saying, that's why my sister was on your jury. So it goes in for a new trial, the juror gets brought in, and the court learns a lot of things. You can't put, and the trial judge said, well, if she disclosed that her brother was in jail, we wouldn't have learned much more. You can't pretend. You're trying, the defendants here were entitled to an impartial jury. If you've got a juror, if you find out you've got a juror who sat on that jury who was not impartial, and you don't find out till afterward, it's still an error. So you have to look at what's
I guess what the judge was saying is that at the time, it would have been really difficult to make that connection between the Lucerne Street Dogs and this juror that comes later. So at the moment, it would have been, I have experience with the law, that being my brother is in jail.
But I think that,
Which would usually tend towards being against the Commonwealth, ironically.
Right, absolutely, that's true. But I think that in that context, when you're the trial judge post-conviction, and you've got all this information now, you can't pretend that it doesn't exist, and that the person didn't sit on the jury, and that the person didn't convict these people.
But I think what we're supposed to do is decide whether there would have been a basis for cause challenge. So could you talk through for us exactly how we should decide that here? And particularly, obviously the Commonwealth is saying there was so little there that, nothing further, and that's what the judge found. There wouldn't have been a for cause challenge. Do we imagine whether someone would have asked, what is your brother's name? Do we speculate that someone would have run his query? Could you talk us through how we do the for cause analysis here?
Well, I think, thank you, Your Honor, that's correct. If she disclosed, my brother was convicted, is incarcerated right now, is convicted. I mean, I've read enough transcripts. The next question is, what county is it? It's Suffolk County. Okay, what's your brother's name? What were the charges? What was going on? And in this case, just that alone would get you dismissed for, can you be fair and impartial? Yeah, but usually
Well,
on
this is a little bit weird because usually that scenario, it'd be the government asking for the person to be excused.
Exactly, and it likely would have happened. But we're in this posture, and so as far as the for-cause challenge, I mean, even leaving aside what could have been learned and what was learned about this juror's connections to this case, however tangentially or peripherally, the fact that she chose to withhold this information, material information, is itself a powerful indicator of bias, which the First Circuit just recently said in the Tsarnaev case. And the site for that is 96 F 4th 441. That alone can be enough. And as Justice Blackmun concurred in McDonough, that in most cases, the honesty or dishonesty of a juror's response is the best initial indicator of whether the juror was in fact impartial. So you don't learn these things till after.
But we here are a bit hemmed in in our speculation by the factual findings below, which were to credit the juror that she did not know about, as she put it, the lifestyle choices of her half-brother. And, she did not know, and we have no, the judge found that she believed the juror that she did not know. So she, on the record before us, it's not that she was specifically hiding her brother's specific connection to these groups. It's just that she chose not to divulge information knowingly, as the judge found, gave an inaccurate answer. So what is your best case for the proposition that simply knowingly not divulging or knowingly giving a wrong answer is enough because it shows a disinclination to follow the judge's instructions?
I would say that any of the cases out of the First Circuit that talk about that, because that, again, going to my point, that a juror who consistently will use her own notion of what she's going to tell the court and ignore the court's instruction and do what she wants to do.
Well, in the Sampson case, which is I assume what you're referring to, there was a lot more dishonesty. That juror had hidden, I forget how many questions, so it was like 7 or 10 questions she had lied in response to. And then the First Circuit went through a bunch of different ways in which those dishonest answers really kind of aligned with the case in some ways.
Yes.
So what is your best sort of similar analysis here?
Well, I mean, along with the fact of the lie about something highly significant, at the hearing, she testified that she didn't, she knew about her brother, but he didn't bring that sort of nonsense to me. And her daughter's father, and he didn't bring that kind of nonsense to me. And you can't ignore, she knew there was nonsense.
Was that untrue?
Well, that's what she said. She testified to
Right,
that.
right. And weren't they estranged at the time?
I'm sorry, I don't understand the question.
Well, so in Sampson, the juror continued to lie even post-trial when she was brought in for questioning. Are you suggesting that that's what's happening here?
Certainly did continue to lie. She testified at the hearing that she didn't learn that her brother was in a gang until after he got out after the trial, and she read the article and it said he was in a gang, and she said...
So the fact that she learned from an article that he was in a gang was something that she should have disclosed?
She talked about it with his mother
If
and her
The
sister.
gang affiliation?
About the article, what the charges were
But
about and what it was
if
about.
If we credit the judge and find it's not clearly erroneous, at bottom, we have a misrepresentation about the custody, about the brother being in custody, and as I think it's called, that nonsense, the gang stuff is out of the equation, correct? If we credit the judge.
If you credit the judge as
If
far
we
as...
find, if we
right.
find no abuse of discretion and we follow the
And-
judge's
and-
findings.
right.
At the best case scenario for you, if we do that, is a misrepresentation that nobody in my family's been involved in the law, up to including the brother's incarceration, correct?
Yeah, and I would say that that's a clearly erroneous decision based on what was developed. So, and I don't think
But
that...
does your analysis as far as prejudice depend upon that finding, or is the fact of incarceration enough for you to get the four-clause challenge?
Yes, absolutely. But I also think the court can't ignore what happened here, that these defendants and this juror had connection that was undisclosed and was never learned about. And what triggered this whole case was the fact that her brother taunted Mr. Ortiz with, "That's why my sister convicted you." That's how this started.
Except for we're trying to figure out what the with the next case where you don't have all of those things that came out in the end.
I think this court has to just reaffirm Emerald because it is the clearest explanation of what you do in that context. But I think the court also has to say that a juror who sat on that jury, and if that's discovered post-conviction, you can't pretend that you don't know what you learned post-conviction on investigation.
Okay.
I think you just can't.
All right.
Thank you.
Thank you. Attorney Hartley.
Good morning, and may it please the court, Brooke Hartley for the Commonwealth. And I'd just like to note for the court that members of the victim's family may either be present in the courtroom or watching on the live stream. This court should affirm the orders denying the defendant's motions for new trial and for disqualification of the trial judge. Turning first to the juror issue. The judge properly denied the defendant's motion for new trial, where juror 15 answered the question inaccurately, but without intent to deceive. The defendant has not met his burden. Under the first prong of Amaral, the defendant must show that the juror failed to answer the question honestly. And I think it's extremely significant here that that is a question of fact that rests with the trial judge, only to be disturbed if clearly erroneous. And there's a reason for this. That's because a hearing permits the trial judge to observe the juror's demeanor and to evaluate the juror's answers.
What do we do with the relevance filter that the juror put into the answer?
So I think the relevance filter is directly related to the juror's observation, the judge's observations of this individual and the motivation for lying. So the judge had the opportunity to lay eyes on this person and determine whether or not the person was intending to deceive the court. So there's no question that the juror had this information in her head. She knew that she's related to Carl Baxter, but she didn't know at the time that that was responsive to the question. And I think if you look at the testimony at the hearing.
Didn't she know it was responsive, but she thought it didn't matter?
And I think that's kind of the same thing. So she made this relevancy determination on her own, which was wrong. That's not what we want jurors to do. But the remedy for that isn't necessarily a new trial. The remedy is to bring that person in for a hearing where the defendant makes a showing, to bring that person in for a hearing and for the judge to lay eyes on that person and to determine what the motives for that inaccuracy were. And that's how you get to honest. And so I think if you look at the transcript.
But is the judge adding another element to it? I mean, the juror knows it's inaccurate, but then the judge is adding this, okay, the juror's doing their own kind of determination of what the legal requirement is. Isn't that new? And isn't that a question of law, not a question of fact for us?
I don't think so, Your Honor. And I think if I go to the really the lines at issue from the transcript here, it illustrates why. So the judge asked the juror, can you just tell us with respect to Carl, why did you check no to that box? And she answers reasonably, because Carl didn't live in my household. Then the judge presses further with what's really at issue here is the or family part. And the judge says, did you think of him as a member of your family? And she says, yes, but I didn't think he had any relation to this trial, so why would I say yes? Now, when I read this transcript, I think, a lot is lost when
That's a big no-no, what she does there, right?
Of course, and we don't encourage jurors to do that. But again, I think the remedy is the hearing. But what I want to point out here is that the words on the page of the transcript, there's a lot lost that we don't get, that the judge did get. So when I read that, I unequivocally said yes, but we don't know what the juror's demeanor was when she answered that question. Did she say yes and then go on? The judge does know. So, just because she's aware of this biological relationship, that leaves out a lot of important context, I think. This is an individual, the juror only found out that this person was incarcerated through reading a newspaper article. This is her half-brother.
I thought she had confirmed it with other family members.
After she read the article. So she
Right,
first...
but before she was impaneled.
That's right.
Okay.
But
so at the time of impanelment, she knew that her half-brother was incarcerated, and she identified him as family.
So she identified him as family when pressed afterwards at this hearing. I think my point is that...
And can I add another fact?
Sure.
And the newspaper report, whether it's accurate or not, reported it as a gang-related. So whether she knows he's in a gang or not, she's aware that, the Boston Herald has described him as such, right?
Certainly, yeah. She learned from reading that article that he was the leader of the Lucerne Street Dogs. She didn't know that before. She didn't gain any other further information after, but she was aware of that. And I think my point here is that her response to that question, no, doesn't necessarily, just because it's inaccurate, mean that she was intentionally trying to deceive the court. I think family means different things to different people, and you're going to get some varied responses here, which is why the judge gave those further instructions about relevancy, which she still obviously didn't heed, but I think that just goes to show that she, in her mind at the time, believed that this was not a responsive answer to the question.
I'm sorry, go ahead.
I was just going to say, it seems like your rule is pretty broad, and it allows jurors to determine what's relevant, what's not relevant, without needing to be honest on the questionnaire and during the voir dire.
Well, I disagree with that, Your Honor. I think jurors absolutely need to be honest, and the remedy, again, I don't think we want to encourage jurors to use their own relevancy filters, but the remedy for that, it's going to happen, but the remedy for that is to bring the person in and to have a hearing. That's how the defendant's due process rights are satisfied, by the judge getting to lay eyes on this person and determining whether that person is biased or not. And I think if you look at McDonough Power Equipment, it's analogous to this case and instructive for this court. That's a case, it's a civil case, of course, but the question at issue there was how many of you have yourselves or any members of your immediate family sustained a severe injury, not necessarily as severe as Billy's, that was the plaintiff in the case.
The problem with that analogy is that case required the juror to make a relative assessment. And what Justice Rehnquist, I think, says in his decision for the plurality of the court is that, different people think severe injury is different things. Here, whether or not her brother was incarcerated is not a relative, something that you gauge relatively.
Well, I disagree, Your Honor. I think perhaps it's more clear when the juror is determining what the definition of severe injury is, although the injury was quite similar to what happened in this case. But the same is true of family. This is an individual who had 6 half-brothers and sisters. This is a person who never grew up in the same household as Carl Baxter and who, as we'll find out at the hearing, had almost no relationship with him at the time. Later, they developed a relationship.
So your position is that is that relatively she didn't consider him family?
Yes, and I think that's what the judge found. And I think that's why we have to be careful about this knowingly inaccurate.
Can we just back up? I thought that the judge very specifically found that she did consider him family. The juror was asked that question, did you consider him family? The juror said yes, and the judge credited that she considered him family and nevertheless knowingly inaccurately answered the question.
I think what I'm trying to capture is that she didn't think that it was responsive to the question.
I take your point, but I even granting that you're of course right that the term family can mean many things to different people, and in that way it is similar to the question about severe injury. In this case, it seems like we have clear factual findings that this juror did consider her half-brother to be family. Even though the word family could be open to interpretation, we have a factual finding that she did consider him family and that this was a knowingly inaccurate question.
It was It was knowingly inaccurate in that she had this information somewhere in the universe of her brain. She was aware that she had this person was her half-brother. She had this biological relationship with him. I think the issue is whether, when she answered no to that question, whether she thought that was responsive to was this person a member of your household or family. And I think her answer at the hearing, what she first says is, no, because he didn't live in my household, is also very telling. And again, I think we have to, I don't think it's an appellate court's place to second guess the trial judge's findings where she was able to observe this person's answer. And again, she said yes, but did she say yes? Did she say yes? It's difficult for us to know just by reading the words.
But I think Justice Stewart's point is that the judge found that she thought he was family.
And I think that's true.
So it wasn't a relative thing. Is he severely injured or not? It was really definitively, yes, he was my family, and I chose not to disclose it because I did not think it was relevant.
I think that's true, but I think if you get to, so the judge found that because that it was not dishonest, because it was not, she did not intend to deceive the court, and I think that has to be part of the definition of honest.
Where in Amaral does it say that the juror's motive for dishonesty comes into play?
So that comes from McDonough, and it's the motives for concealing information may vary, but only those reasons that affect a juror's impartiality can truly be said to affect the fairness of the trial. And I think that's what's at the crux of this honesty determination.
But that still short circuits the defendant's right to move to disqualify this person for cause. Because, I mean, you keep glossing over that, but that's a really important thing. So we don't just get to sit back and say, please tell me the truth, then please tell me the truth, because that's the second time when Judge Faber can't say, don't use your definition of relevance, right? She specifically tells them that. And even with that, she goes off and doesn't say this. And I guess the question that I have for you is, you keep saying that we then get to go and the trial judge gets to go in and say, now I'm going to play Karnak the Magnificent and try to figure out whether or not this person was trying to lie to me. But the second part of that short circuits the defendant's ability to say, I want this person disqualified. I want this person disqualified for cause because I don't want to run the risk that there's some snake slithering around in this person's head that would inure to my client's detriment.
So I think the second part of the test is not whether the defendant would raise a challenge for cause. I think it's, as Justice Gaziano said, it's probably likely that the Commonwealth would have raised a challenge for cause here, but the question is whether there was a basis for the judge to allow a challenge for cause, to find that juror is not impartial. So it's not, Right.
But that wouldn't have, that's not a huge thing, right? Because whenever we get the question of whether you would choose to credit the testimony of a police officer more or less than any other witness, that's routinely asked, and if the hand goes up, it's routinely allowed. So we're not talking about a huge burden here for the 3 defendants in an accused gang-related shooting, retaliatory shooting, to say, I don't want the person whose brother happens to lead a rival gang on my jury.
They didn't know that at the time.
Perhaps, but
yeah.
they know that he was the leader of the gang.
Yes, and so I think the judge, in her discretion, if it had gone there, if the juror had answered the question, yes, could have allowed a challenge for cause, but that doesn't mean that the judge was required to allow a challenge for cause. If you look at Mattier from this court.
How do we ignore the follow-up, the obvious follow-up question point, which is, once this person's identified, a lot of bells and whistles are going to go off, right? That, okay, we got a gang issue here. They're going to identify this person's name. Isn't all this going to come out if she answers honestly?
No, Your Honor, because what the findings at the hearing were that the juror, and this is what's really important here, certainly defendants could have done research and found out more about Carl Baxter if they knew his name.
But if she answers the question honestly, the first question, do you have a brother who's been incarcerated? She's going to say his yes, and then they're going to ask his name. And isn't that going to generate a defense challenge because they're going to know who he is?
Well, maybe it would have, but the question is, again, not whether the defendant is going to raise a challenge. The question is whether the judge is required to excuse that juror. And if you look at the juror's testimony at the hearing, there are several crucial findings. So the juror was, yes, aware that Carl was incarcerated at the time of the trial because she had read about it. But between the time the juror read that article and the beginning of the trial, the juror didn't learn any other information about the gang or about Carl's affiliation with the gang. She never had a conversation with Carl about why he was incarcerated or gang affiliation.
But again, I'm not concerned so much with it's. They're going to say she's going to answer the question honestly, yes, and then isn't the Herald article going to come out, and then no judge is going to allow this person on if it's a rival gang person, right?
Well, I think that's all speculative, and what matters under McDonough and under this court's case law in Amaral is the juror and whether the juror was impartial. And based on her universe of knowledge at this time, she didn't know anything more. And the judge found to that effect that if she had answered the question accurately, further questions would not have yielded any information because she didn't know anything. All she knew was that she had a brother who was incarcerated at the time. She didn't know about anything about the Lucerne Street Dogs. She read it in the newspaper article. She didn't know about any affiliations or rivalries between the Lucerne Street Dogs. She didn't know anything about MOB. So
is it irrelevant what the defendants would have found out if she had been honest?
Yes, I think it is. I think the question, we're looking just at this juror and what this juror knew at the time and whether or not this juror was impartial. I think that's the crux of the inquiry under the second prong, under the prejudice prong.
Chief, could I ask one? Counsel, I just want to go back to at least the first question again. So you have a situation where the trial judge during voir dire asks this question. The trial judge follows up after the fact and says, please don't superimpose your definition of relevance. Tell us everything. And then years later, during this evidentiary hearing, you say because there's an ability to observe this person during the hearing, that precludes us from finding that it was clearly erroneous that she intended to deceive. Is there ever a chance, or is there ever a world where that can't always be said after an evidentiary hearing? And we've said that after evidentiary hearings, right?
Yes, I think if there was testimony that was, conflicted the trial judge's finding, then this court could certainly find it clearly erroneous and overrule that judge's factual finding. But this isn't that case, Your Honor.
When she says, I thought it was irrelevant, even though I told you don't add your definition of irrelevant or relevance, that's not clearly erroneous?
No, Your Honor, because the trial judge determined, and I think a lot of this comes down to what the definition of honesty is. The trial judge determined that she was not intending to deceive the court. And the Commonwealth's position is that the definition of honest is not just knowingly inaccurate, but is that intent to deceive the court. So whether or not she had this knowledge in her head, was she purposely withholding it to conceal it from the court? I think that's the crux of the issue.